All right, welcome to Senate Judiciary. We will be considering two bills today, House Bill 72 and House Bill 43. On the agenda, it was House Bill 43 and then House Bill 72, but in consultation with the sponsor of both of those bills, we've decided to change the order. So we will be considering House Bill 72 first, just so the public is aware. And with that, let's go ahead and call roll.
Senator Crago,
Here.
Senator Crum,
Here.
Senator Hicks,
Excused?
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right, thank you. Representative Lawley. House Bill 72, Protecting Women's Privacy in Public Spaces Act. Why don't you go ahead and introduce the bill and then walk us through it?
Thank you, Chairman Olson, and good afternoon, Senate Judiciary Committee. I am presenting to you again House Bill 72, Protecting Women's Privacy in Public Spaces. House Bill 72 ensures that women and girls are safe and respected in places where privacy is essential: bathrooms, locker rooms, showers, overnight accommodations, and correctional facilities. The bill provides for clarity, and it creates consistent, common-sense policies that prioritize privacy and safety in public schools, higher education institutions, state facilities, and correctional facilities. House Bill 72 sets some clear standards that say that men cannot access women's intimate space like showers, restrooms, and housing facilities. Also, the bill gives women a way to hold institutions accountable when those protections are violated. 12 other states have enacted women's privacy protections similar to House Bill 72, and many other states are considering these kind of bills as we speak. Unfortunately, Mr. Chairman, men who assert female identity are currently allowed in Wyoming to enter women's private spaces like showers, restrooms, and changing areas. We have documented incidents here in Wyoming. Today, you will likely hear about some of those incidents and concerns. I have been contacted since this bill was filed, and even before, by some of my own school board members in my district, school board members from other districts, superintendents, teachers, and parents about issues right here in Wyoming. For many of us, this was one of the most frequently heard things as we campaigned door to door. I heard stories of discomfort and fear when policies are not clear, leaving institutions scrambling to balance privacy concerns with the risks of lawsuits. Many constituents told me, it's time for the legislature to do something about this. And I agree, it's time for the legislature to do something about this problem. I believe that women and girls deserve to have their privacy and their dignity safeguarded at school, in public facilities, and their right of privacy and safety should not be dependent on others' beliefs about gender. President Trump's executive order on defending women from gender ideology, extremism, and restoring biological truth to the federal government was issued his very first day in office, shortly after he was inaugurated. It's a priority everywhere. And quite frankly, that executive order outlines really what this bill does. It starts with biological definitions that we will use to navigate this space. And then it goes to the idea that we have policies we put in place and that we bring them across the state in terms of state buildings and facilities, correctional facilities, and specifically in the education space as well. There were some amendments on the House side that you see there, and I just want to kind of go over a number of those. They were friendly amendments, and as we really responded to some different specific concerns people had. The first one is an amendment that addresses the issue of coaches who are of a different sex than the team, and how do they handle that with team meetings and things, and gives some direction on that. It's actually broader than just coaches intentionally, because there are other circumstances like that that could occur. We added language for municipalities related to reasonable steps, including signage and policy making. Again, I think it added to the bill. We did add county jails. We carved out some accommodations for county jails because in particular in the smaller counties, they face some unique limitations, both in terms of personnel and space that they have available and the changing population from day to day. Amendments clarifying exceptions for caregiving in all public facilities and educational space. These caregiver exceptions are really for whether it's a mom with a young son, a dad with a young daughter, what to do in terms of the bathroom. Also, if you're taking care of a senior, one of your parents that really needs some assistance, that would be a caregiving situation as well as a disability. So those are all covered in the space, both spaces. You're going to see the bills divided into sort of two broad categories: public facilities in general, and then educational spaces. That's because we do things differently and deliberately differently, intentionally differently in the educational space, where there are a lot of different things in terms of what happens in the school, what happens on overnight trips and things like that. So that space is navigated very specifically for the education, and it's defined not only as K through 12 public schools, but also regarding the University of Wyoming and our community colleges are all covered under this, the educational space part of the bill. We also added in the public space area, the public facilities area, an exemption that existed in the education space, which is the right to permanently temporarily designate or redesignate an area. So let's say you're having a girls' tournament, you can redesignate a locker room that was traditionally the boys' locker room and turn it temporarily into the girls' locker room. So those kind of things give a little bit of flexibility and unusual circumstances to the facilities. And with that, I will walk through the bill a little bit, and I am going to have some amendments, and we'll talk about those in a moment. But I want to just kind of walk through what you see now in the bill and the engrossed copy of House Bill 72. Really, there's a lot of definitions here, and the definitions matter. So one of the things I will point your attention to in the definition that's really important is the definition of male and female. One of the things I'm trying to do, I have some other bills. One is a sports bill, amending the sports bill to include University of Wyoming, and they will use these definitions. I was able, with cooperation of the sponsor and the What is a Woman Act, to get these substituted in if that act were to pass. So I think there needs to be that kind of continuity and clarity in our statutes on gender issues. It's, as one who has had to use and interpret the law, it's really difficult sometimes to find these different definitions on basically the same subject. And again, that lack of clarity really does create some problems, and it really cuts against effectiveness. So that you see the definition of female, and later you'll see male, and public schools means a public school or a charter school, which is a public school. Restrooms, sleeping quarters, all these things are defined because we're going to see some different circumstances as we move through the bill. We're going to see overnight trips in K through 12, the band going to state band competition, and how are the rooms assigned for those hotel rooms. That's really becoming an important issue for parents in this space. And so we address that. Then we address, for example, with UW, we're going to see as you walk through here that we also deal with assignment of dorm rooms. And again, it's about someone being mandated, if you will, to accept a roommate that is a biological male, a female. So we cover all of these different spaces and try to navigate that. Again, I just point out that there's just two basic tracks in the bill. The first one is public facilities. And we say specifically, by definition, that includes correctional facilities. I think you'll hear from, and we certainly did on the House side, the Department of Corrections, that they have no problems with this bill. They're actually already complying with it. And it would be beneficial to have it in statute, I believe, is what you'll hear. And, there's, I know time is short, but we could talk a lot about the issues in women's prisons. It is a substantial issue. So as we navigate this space, there's a contrast between two different kinds of spaces, and that's multiple use and single use. And so you'll see that referred often in terms of guidance, and if it's this, then that. So that's the first thing we look at, multi-use, and most of our conversation is around multi-use and how to navigate that space under the definitions. And then concerning the single use, it will become one of the best options. Any single use, bathroom, shower room, is an alternative. It could be an acceptable alternative. What you're going to see broadly, the policy is simply this, that a male shall not enter those female spaces, and that the districts, anyone can make accommodations, and they have really every bit of kind of accommodations that for them, but there's just one thing that can't be an accommodation. That they say, well, there's no girls in the girls' restroom, you can go ahead and go in there. That's not going to be an accommodation. It's basically a single use or to use the bathroom of your biological definition. I'm trying to, and again, you kind of see the language that you'll see somewhat repeated, every multi-occupancy changing areas, and I'm on page 6, air restrooms and sleeping quarters designated for one sex shall be used only by members of that sex. You'll kind of see that terminology throughout. No person shall enter a changing area restroom or sleeping quarters that is designated for male or female unless the person is a member of that sex. And then you see on page 6, line 9, you see this idea of accommodation. There's nothing that stops him from creating accommodation, but what is not a reasonable accommodation is to kind of clear out the girls' restroom and let that person go in that restroom. Then we have, on page 6, we start with some, what I would call, shall not apply to, so exceptions, if you will, and it has to do with unisex use, unisex bathrooms, which really are a form of a single use. And then we have some exceptions about employees who enter changing areas and restrooms to clean, but basically it's when it's not occupied. So there was also some exceptions for medical assistance or caregiving. Obviously, if you have a medical emergency and people have to come in to help someone, that is an exception to go in and do that. The caregiving is what I referred to earlier, small children, disabled students, or in the education space, but a disabled person in a public facility, or even an older person who needs assistance. So, and then we see official duties, and this is where we start looking at the employees who enter, for example, a restroom or sleeping quarters. And again, I'm on line 11, Romanet 4 on page 7, a person or employee who enters the changing area, restroom, or sleeping quarters while in the performance of a person's or employee's official duties. And then natural disasters. I mean, we're trying to help. Remember, the really point here is biggest point is to set policy for, particularly in the education space, and then also in the public facilities space. And so maybe it seems kind of weird to put something like that in there, but I think it's important that we help them navigate these kinds of issues. Then we have, again, I referred to it earlier, but I call it the temporary designation clause, about they can temporarily designate for use by that person's sex. They can change it temporarily to fit the needs, a particular need. The page 8 talks about causes of actions, elements of those causes of action. And then on page 8, paragraph F, we move into correctional facilities. There's only a small amount that just carves out some things that are unique to correctional facilities. Then we get, in page 9, then we move to the educational space. And you're going to see a lot of similarity, but you're also going to see some specificity in some areas that are some of the unique challenges for education. But the same basic principle applies. They shall designate for use the facilities by which one's for male and which one's for female, which one boys, girls, and then that you only use the one of your sex. So they don't enter the changing area unless unless that person is a member of that sex. So they just kind of go through some of the different elements and within the educational space. And then on page 10 at the top, we start talking about student housing, which really kind of more goes to community colleges and University of Wyoming. Shall provide students the option to be housed with persons of the same sex. That's all we're asking. It's about compelling someone. And then sleeping quarters, again, this distinction in language, I just want to point it out to you, housing for student, resident housing, that's dorm rooms. But the next paragraph is about sleeping quarters for overnight trips, which is really becoming a really important issue for parents right now. So we basically just say that they have to assign to the birth sex. So then there's some changing area language and with the same prohibition. And then we now have, again, some exceptions. Shall not apply to single occupancy, changing rooms, rest areas, et cetera. And the second one is, again, the exception to temporary designated facilities. You can obviously do the temporary designation and then it is not under the prohibition. And then you have on page 11, line 9, for, again, temporary emergency, and then cleaning when not occupied on page 11. So again, on page 12, we have, again, medical assistance and caregiving. And then language is on page 12, Romanet 6, a person who is in need of assistance and for the purpose of receiving that assistance is accompanied by a family member, legal guardian, or other person's designee who is a member of the designated sex for the single sex changing area, restroom, or sleeping quarters. This has a little bit different language in it, primarily because we're talking about educational space and teachers, and making it clear how they can assist and who can assist. Again, on page 12, we go onto ongoing natural disaster, and then school officials who are acting in an official capacity. Then we have on page 12, written requests for reasonable accommodation. And so that there's just a provision that there's a process for that. But again, the accommodation will not be to go into the restroom of something other than your sex. So, but there are it gives the facilities, educational facilities, abilities to navigate the space and provide that alternative. And then we have, starting on page 13, we also have some causes of action. And again, we're looking at things like an official told someone that they could go ahead and use the restroom that was not of their sex. So that's deliberately violating the policy. That would bring a liability. And then the second way that you would violate the policy as an educational facility is to fail to take reasonable steps to prohibit that person from using the changing area of the opposite sex. And what would be reasonable would be circumstantial, what the circumstances are, what's reasonable and what's not reasonable. And again, some of this will become a matter of policy making for those institutions, for school boards, et cetera, to navigate what are the directions for those folks that are running the facility. There's a specific cause of action related to acknowledging that there's a cause of action related to the overnight trips. There's some statute of limitations, some financial damages for incidents. And then we get to page 15, and there's some additional damages that include attorney's fees and costs, and there's basically, that kind of covers that. Then we have this section inserted, which was part of an amendment, and it's going to go to the amendment I'm making, but on page 15, line 17, we, over in the House side, I had a lot of conversations with those that represent our sheriffs and our police departments, and some concerns about the smaller counties' jails. And so we worked together, making some accommodations for them. But you can kind of skip those pages, because I'm really asking you, and you have it in your packet, to amend this statute and take that out, because I'm further going to amend the bill, ask you to amend the bill to not cover our counties and our municipalities in great part, due to the concern I have about what may happen to the counties in terms of what we do with property taxes. And this could potentially, on some of the smaller counties, put an additional burden and a kind of unfunded mandate. And so this will give them policy direction, but they aren't really under it. So that's why we'll be taking that out if you so allow. And that whole section concerning jails will be eliminated, because they will no longer be under the bill. Then on page 19, I basically put violation of this bill as go into the governmental immunities statute and say that the causes of action created here, there's no governmental immunity for those. So that is, in essence, the bill. And again, part of my goal was to really provide a comprehensive policy. And you're going to hear today that from some folks in the school system, for example, how these policies meet their needs. And again, Mr. Chairman, I am going to ask for.
Representative Lawley, from a 10,000-foot viewpoint, tell us what you exactly want to amend with this amendment. I know it's deleting jails. You told us that. What else is a lot of delete? So what
Right.
else is it deleting?
I think we start, thank you, Mr. Chairman. I think we start with it takes out from the definitions, local government. So counties and municipalities are now, they were originally in the bill, and the bill covered them. So we are first and foremost taking them out of the bill. And so we're removing some definitions of local government and things that are not needed. And because we're taking those out, there's no longer a need for any provisions concerning county jails.
Okay.
And that's really what it does. I think there's one other little fix where on the facility side, there was a definition that included educational facilities, which created confusion because we had a separate section for that. So we took that little phrase out, and educational facilities. But other than that, that's what it does. It basically takes the counties and municipalities out, and it then eliminates the need for the particular accommodation that was given for the jails.
Perfect. Questions for Representative Lawley? Senator Crum?
Get my thing on. Thank you, Mr. Chairman. I do appreciate the direction of the bill. I do have several questions, so just more on the practical side of things, how it works. Is this, the way I read the bill, the title is Protecting Women's Privacy in Public Spaces. Does this apply to both men and women?
Yes.
Representative Lawley?
Thank you, Mr. Chairman. Yes. Yes, it does.
Okay, perfect. And the reason I ask, I had several people approach me knowing this was coming
Senator
up.
Crum?
Mr. Chairman?
We're getting a little sloppy here.
Yes, we are, Mr. Chairman.
I am Mr. Chairman.
Yes, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman. So, Mr. Chairman, my question here is, in my community, we have been asked by several people that women go into men's rooms during large events. You know, they're usually a longer line. Would that be prohibited, that women cannot use men's room to use the facility under this bill?
Representative Lawley?
Thank you, Mr. Chairman. It would be prohibited. I direct you back to what types of facilities are covered under this bill. But so if you, let's say you're at a hockey game at a city rink or a county rink, this bill would not apply to them. I hope it provides guidance for them, but they're not governed by the bill if you accept my amendments. But if you are in a state-owned or leased building, yes, those rules would apply either way. Because the bill is written in terms of you have to go to the restroom of your biological sex, whichever one that is.
Senator Crum.
Thank you, Mr. Chairman. A follow-up question, what happens when, Mr. Chairman, a restroom would be out of order? Say the women's restroom is out of order and the only one available in a public facility is the men's room. How would that work?
Representative Lawley.
Thank you, Mr. Chairman. Well, I would say that one possibility, if there's only one men's restroom and one women's restroom, I say they need to get it fixed fast. But, if there's several in that building, they could temporarily designate a men's restroom as a women's restroom.
Mr. Chairman, my question really is on this, probably the smaller facility with one men's and one women's restroom, and say if it's like, when I call a plumber, it's sometimes a day or two before they can get parts and things, so it's down for a day or two in a facility with only one men's and one women's restroom.
Mr. Chairman, thank you, Mr. Chairman. Again, if it's a single use, it could be turned into a unisex bathroom. And so again, I'm not sure the exact circumstances, but that would be an option. If it's a single use, that you just turn it into a unisex until you get the repairs done.
Thank you, Mr. Chairman. Another question, kind of on the same track, and let's say we're in a facility that it's a public facility, it's in a smaller community maybe, and what I've seen happen.
Bags.
Mr. Chairman, what's that?
In bags, maybe.
In bags, yes, in a small town like bags, right there on the Little Snake River. I've seen many of the facilities, you have a locker room, but then, and with the younger age, a lot of times they have co-ed teams, little girls and boys playing the same basketball team or something along those lines. And the only real meeting room is, once everybody's dressed, is to go into the locker room is really the only meeting space. Or you got the gym and a locker room where you can go outside. And so is there some kind of accommodation that would allow, once everybody's fully clothed, that with a coach of each sex or something, that they could go into the locker room and be okay, Mr. Chairman?
Representative Lawley.
Thank you, Mr. Chairman. That's a great question. It is actually covered in the bill. And the key was exactly as you described, that everyone is dressed. And so we've really tried to make it where they can accommodate and navigate some of the challenges they face. But I will say at the beginning of your example, you were talking about in a small town, and if it's a facility of the city or the county, this does not cover them. So it would have to be a state-owned or run facility, which would include educational space.
So like,
Senator Crum.
Mr. Chairman, for example, the nice school there on the Little Snake River.
Yes.
So, Mr. Chairman,
Yes, Senator Hicks.
just for clarification, we do have state land down there, and we've got designated women's sagebrush to go behind the bathroom on, and we've got men's sagebrush that you can go behind on those state sections when you're out there. And so I'm just wondering, if somebody went behind the wrong piece of sagebrush, would they be violating the terms and conditions of the bill here?
Representative Lawley.
Mr. Chairman, a wonderful and entertaining question, and I actually learned something, that there's men and women's sagebrush, and so I think you're probably okay.
Okay, well, I just wanted to make sure, Mr. Chairman, certainly don't want to criminalize anybody down there for using the wrong sagebrush to go behind.
Senator Kolb.
Well, thank you, Mr. Chairman. Representative Lawley, just a couple questions. I guess after I was reading this onslaught of amendments here, It's hard to track in and really, figure out really what you're up to. But I've kind of, after you explained, it was mostly about local county jails and city jails. But my question, as it involves that, what is it, business as usual? You putting guys and women's areas in a jail, or is there are there any protections that are going to be afforded women or men? I'm with Senator Crum, that it goes both ways here, that we do something like this bill intends to do for the state level, in those type of facilities. I don't know, I'd like to know so I'll ask you a couple questions, just two at a time, what's going to happen to those facilities? How are they going to, is anything going to change? Maybe that's a better way of asking that question. And the next one is a question about how you define sexes. Or is it passé to use DNA now for chromosomes? I mean, the chromosomal test for male and female, or is this, is this the better way of phrasing it now in the year 2025? Thank you, Mr. Chairman.
Representative Lawley.
Thank you, Mr. Chairman. Senator Kolb, concerning the county or city jails, their intent was to comply with this. I think that's still their intent, whether they're in the bill or not. But we were helping them navigate, particularly the smaller counties that have limited space, limited personnel, and their population changes quickly. So they had to have some special types of redesignation, for example, accommodation. So, but, everyone involved there, and certainly the group that represents the sheriffs and police chiefs were in favor of the intent of the bill. And so, and they may be here and maybe can speak to that, but so it doesn't cover them. And partly, as I said earlier, that, we're about to do something on property taxes that may have different types of effects in different counties. And I didn't feel maybe this was the time to give them a potentially unfunded mandate if it would cause some needed changes within their physical space. But I could foresee us coming back and amending them, counties and cities, into the bill. We are going to provide great guidance through this bill, which is what most people want. I don't think with the counties, to be honest with you, and certainly those I talked to concerning law enforcement, have any desire to not comply with what we have written here. I really don't. In fact, I had got just the opposite impression, and they were great to work with because of that. So it was really my decision, though, that we take the counties and the municipalities out.
Let's take Senator Kolb's other question, then we'll get to Senator Hicks.
Well, yeah, so there is no protection. I'm concerned about a couple counties that maybe not following this, and I agree wholeheartedly what they're trying to do. And I do understand the reasons why you stated your reason, why you took this position. However, there's no protections then. And then the next one is DNA. I had DNA. Why aren't we using DNA?
Thank you.
And the other one, I'll just say it now because I'll be done with this as my first set of questions, is you had visual separation within jails stated as one of the criteria, to separate people. Mm-hmm. And I wondered if you considered voice separation, because there's a tremendous amount of harassment that goes on with verbally besides visual. And I just wondered how you thought about that. So those are my two other questions. Thank you, Mr. Chairman.
Representative Lawley.
Thank you, Mr. Chairman. First, a clarification on the last one. Are you talking about in a county jail or a Wyoming correctional facility? The facilities are very vastly different, so that would make a difference in my answer.
Senator Kolb.
Well, I asked a couple questions. The one that I spoke about was at the state facilities for separation. That was the last question, but the other one was back to a DNA question. Thank you, Mr. Chairman.
Yeah.
Representative Lawley.
Okay, thank you. The DNA question, I assume you're referring to the definition in the bill of male and female. So again, this is an objective deposition. I feel like I'm in a deposition right now. No, the definitions are basically have developed over time and some of it relates to how lawsuits and how courts interpreted. And this is, so ultimately, someone will decide. It isn't really put forward as some kind of initial test. The way this would operate is like things operate today. We enroll children in school and we provide birth certificates. We do these things. And until there is a reason then to go beyond that, then and inquire further, this would be the ultimate determiner. But there are many gateways. So let me give you an example in terms of how it plays out. We have on our side, and I think maybe your side of the hall, a door that says legislators and staff only. That door, if I'm coming up and I go into that door, or you're going up to your chamber and you go through that door, they recognize you and they know that you're supposed to be going, you have authority to go behind that door. So it's going to work similarly, that basically we allow people to enter a women's bathroom if we know them and we have no reason to suspect they're not. But if we don't know them and we're uncertain, we will stop and ask questions. So that's kind of how it works. This bill does not advocate everybody get tested and everybody get proved up and have a special sticker, or it's just not what the bill actually calls for. But the definition may matter at some point. It's very aligned with President Trump's executive order on day one about we will have biological objective definitions, and that's what these are. And these are legally defensible definitions. So I hope that helps on that. Back to the prisons. Again, I think someone from the Department of Corrections will be here. You could maybe ask about that, whether that's a problem. My feedback from them was this bill is very good. We already comply with it, but it's beneficial for it to be in statute as we get prisoners, transgender prisoners in the future. And so I did not hear any concerns about whether this was specific enough in terms of voice, et cetera. So that's all I can answer for you. And again, back to the, well, I'll just leave it at that.
Senator Hicks.
Mr. Chairman, and just looking, and when we get into the civil action, it keeps talking about that you can recover the fee and that you can basically against the facility. And I'm just, is that a term? Because if we go all the way through there and you go from page 13, it says the educational facility gave the person permission to use the changing room. And then it brings in the civil cause of action, and then it talks about you can recover damages from the educational facility. And I'm just wondering how you do that. And maybe that's just a term of art and legal language, or is it the owner or the leasee of the facility? I'm just trying to figure out how you recover damages from a facility.
Representative Lawley.
Thank you, Mr. Chairman. Well, to recover compelled damages, you would need to enter into a lawsuit. And these are the things that would be adjudicated, where it says you may recover attorney's fees, you may not, depending on the determination of the court. So those are really just talking about those actions to recover damages. The more important actions.
Mr. Chairman, maybe I wasn't clear in my question. The question is the language in the bill says a person may also recover monetary damages from, I understand the cause of action, the education facility.
Yes.
Is it the owner of the facility or is it the facility itself that we're recovering damages from? That's the part I'm, education facility. Facility being the operative word.
Well, Mr. Chairman.
Yes. I was reading because there's a definition of public facility on
Yes,
page 4.
There is.
So that line 5, page 8, that says a cause of action against a public facility means what is defined on page 4, Romanet X, public facility. And then,
Mr. Chairman, that's
Go
one
ahead,
of the
Representative
definitions
Lawley.
that's slightly tweaked also just because of,
in your amendment,
I believe, let me look.
Mr. Chairman, I gotta go too.
He scared Senator Hicks away.
Well, my goodness, I hope he returns, Mr. Chairman.
Well,
Yes,
I think
there's
it's
a-
defined, my point is, I think it's defined in the bill. So what it
Correct.
means is what it means.
Yeah. Thank you.
Other questions for Representative Wally? Senator Crum?
Mr. Chairman, just kind of a follow-up to Senator Hicks's question. I look at this and probably, once this bill is passed and becomes law, most schools and things will have policies that say, don't do this, right? Well, then, when it's violated, there's a penalty that the school or the jail or whatever ends up paying. Really, it's us, the taxpayers, that end up paying that. And really, the violator is probably not the school itself. It's probably an individual that violated and not the facility. The facility probably has policies and trainings that says this is it, but it's an individual that violated a policy that therefore violated. Is there any penalties for the person that really violates the policy, or is it just against the institution? Would be my question, Mr. Chairman.
Okay, Representative Wally?
Thank you, Mr. Chairman. Senator Crum, that's a great question. There are other causes of action already existing in law, such as voyeurism, potentially assault or battery, depending on the circumstances that happened, what happened in that situation. And some of those have happened, but those cause of actions already exist. The cause of actions created here are ones that didn't exist, and they relate specifically to the policies that are in the bill, but it doesn't exclude the ones that already exist against the individual.
Thank you, Mr. Chairman.
Good questions for Representative Wally before we go to the public? All right, let's go to the public. Superintendent Degenfelder, welcome. Welcome to a committee that is not the Education Committee.
Thank you, Mr. Chairman. Always good to be to a new committee. Megan Degenfelder, State Superintendent of Public Instruction. Thank you for the opportunity to speak today. I will be brief. Want to commend the bringers' work on this bill. I appreciate that this bill, number one, has been brought. We heard directly from a school district in the state of Wyoming that this was an issue, that they found it difficult to create policies based on lack of clarity within the courts on this issue. And so they believed that having this guidance at the state level would be helpful. I appreciate, knowing that there are several bills that have contemplated this. What I like about this particular bill is that we're also extending into higher education as well, and the work of the bringer to really make sure that those definitions are aligned between some of our other statutes. And so with that, Mr. Chairman, would stand for any questions.
Questions for the superintendent? All right, thank you.
Thank you.
Hold on a second. Can you raise your hand if you're planning on testifying on this bill? Okay. So what I'm going to do, I've got a lot of people online as well. We're going to limit public testimony to 2 minutes, and we'll take our government agencies first, and then we'll move into the general public comment. So come on up.
Thank you very much, Chairman Olson, members of the committee. My name is Patricia Bach. I am the Director of A&I. I have not had the opportunity to be in front of the Judiciary Committee, so thank you for having us.
Welcome.
We are absolutely neutral on the bill. There is one area that I'm a little bit concerned about, and I've talked with Representative Lawley, and she would agree it would be, I believe, a friendly amendment. The state owns public housing. So my easiest example is the governor's residence. And so we would like to see an exception that basically says if the state owns a public residence, a married couple, we wouldn't have to put 2 bathrooms in a master bedroom.
Do you have a written amendment?
I do not, but I can work with whoever is going to have it on the floor and get that taken care of. So it's a very simple, that's the only thing we're concerned about. In some ways, I think you could read it that we could just put unisex sign on the master bedroom But, you know, it's an interesting issue for us. Thank you.
Senator Craigo?
Thank you, Mr. Chairman. Would that all also apply to any other homes owned by the state, game and fish homes, teacherages, et cetera?
Ms. Bach?
Chairman Olson, Senator Craigo, yes, I believe it would. I thought of Game and Fish, YDOT. State parks, I tried to give a call to Director Glenn. I know there's yurts and cabins, but I do not believe there's bathrooms. But they would maybe be considered changing rooms. So those are the things that I'm concerned about. I don't think it's a big issue to get that in the bill. I don't think it changes the bill in any way. It just makes our lives a lot easier as owners of these buildings.
Yep, I would agree that's problematic.
Yep.
So,
That's all I have. Thank you for having me.
all right.
And I'll
thank-
stand for any questions.
Any other questions, committee?
Thank
All
you
right,
very
Thank
much.
you. You gave us back 16 seconds. All right, who's next? Do we have any other governmental agencies wishing to testify? No, looks like we do not, so we'll just go into general public comment. You come on up and fill up the chairs. We'll start over here.
Mr. Chairman, Boyd Brown, Executive Director of the Wyoming Association of School Administrators. Again, I want to praise the bringer of the bill. I think they've done a great job of thinking through a lot of different situations. Actually prefer the House bill that she's presenting over the Senate file that's out there currently, just because of some of the ways that she's allowed for people to go in and do changing rooms as part of their job for IEPs and different things like that. So really stand in support of the bill. I think the last issue was probably something that I was going to bring up as well with teacherages, but support the bill and would answer any questions that you have.
Any questions for Mr. Brown? All right, thank you. Mr. Thompson?
Thank you, Mr. Chairman. Alan Thompson, Executive Director of WASCOP, Wyoming Association of Sheriffs and Chiefs of Police. And I would also like to commend the bringer for the communication that we've had in trying to deal with jails. But I did also want to add that there's pretty extensive, our organization has partnered with some other entities and provided legal-based jail standards. And those are authorized for use in every county in the state, provide up-to-date access to case law and existing law, both from the federal level down to the state level. And this practice of housing different sexes in the same room does not occur in jails across the state of Wyoming. And there's already a mechanism for inmates to grieve that process and use that process to maybe file for lawsuits if there's any claim of that going on. So the practice is happening right now across the state, and I would answer any questions if you had any further questions, Mr. Chairman.
Any questions for Mr. Thompson? Yes, Senator Cole.
Yeah, thank you, Mr. Chairman. On this proposed amendment, what are your thoughts on that? I mean, just what are your general thoughts if this wasn't adopted? Thank you, Mr. Chairman.
Mr. Thompson?
Thank you, Mr. Chairman. I think that our biggest struggle is trying to cover all of those times where we can't determine whether we're going to have male or female employees on staff to go into male and female blocks in a jail. And so the safety and security aspect has been very well litigated over years. We have case law to go by and federal and state law to go by to address those issues and provide as much privacy as possible. But also the Supreme Court has ruled that you don't have that level of expectation of privacy in a jail that you would anywhere else in the United States. So to answer your question, the focus on the state level is my understanding of the amendment. I haven't seen the actual amendment. And I feel that our organizations are going to continue to do the right thing without this law affecting us. Should this the current version of the law pass as written, I feel that we will struggle on the local level for various reasons.
Okay, any other questions for Mr. Thompson? All right, thank you. Ms. Russell? And if you're going to testify, please come up and fill up the seats. There's no reason for us to wait around for you to walk up here. Just fill up the seats. Ms. Russell.
Mr. Chairman and Senators, thank you. I am here, I'm going to speak first on behalf of the Wyoming Republican Party. We stand in support of this bill and appreciate all the work that has been done on this bill and various iterations of it over the years. It has definitely been a primary concern for us that to get law that is needed to defend our privacy. And this is to override rules and regulations that would be in opposition to it. We believe that everyone has a right to privacy, dignity, and safe spaces in the most intimate of human situations. The need for this bill illustrates the consequences of the evolution of public policy on privacy. Being the age I am, I have lived through a bunch of iterations of this, and I remember when I was in middle school, junior high at the time, we moved from private spaces for showering and dressing to public spaces. Other girls in my group refused to take PE from that point on because of their sense of privacy and their need for safety and dignity. That affected their ability to get a full and rounded education. And today, here we are arguing whether or not we can have privacy in these intimate situations. So that shows the evolution 63 years later of what happens in unintended consequences. There's one other thing I would like to bring up quickly. I had the experience of getting an advanced degree in ecology at an institution that was very influential in setting public policy. I know how studies are designed to get the desired result. Somebody brought up the DNA and sexual genome. Most of that research is based on Drosophila and drawing an analogy in the expression of fruit fly DNA and its applicability in the human environment. Behavioral health, all of the policy that is driven from that is largely out of E.O. Wilson, who determined and asserted that we are like ants. And so the ant colonies are the basis of our assumptions on human behavior and development. So I would ask you to seriously question the idea of our genomes being flexible because it's based on fruit fly DNA. And the link between human and fruit fly DNA has yet to be really demonstrated. Thank you.
Any questions for Ms. Russell? All right, thank you. Ms. McCoy.
Thank you, Mr. Chairman. Good afternoon, committee. My name is Patricia McCoy. I'm the chapter chair of Moms for Liberty of Laramie County and a mother of 4 children, 3 boys and 1 girl. I sit here before you today to speak in strong support of House Bill 72. Wyoming bears a unique responsibility as the equality state, the first to grant women the right to vote and consistently lead on women's rights. This historic legacy compels us to maintain strong protections for women and girls in private spaces, a right that previous generations of women fought tirelessly to secure. As both a mother and a woman, I've witnessed firsthand how critical sex-separated spaces are for safety and privacy and dignity. When my daughter participated in school sports, uses locker rooms, or travels to public facilities, she should have the fundamental right to privacy in spaces designated for females. This isn't just about comfort, it's about maintaining the hard-won protections that Title IX established for women and girls. This bill protects the physical safety and privacy rights of women and girls while ensuring reasonable accommodations for everyone. The legislation specifically provides for single occupancy facilities and other accommodations, demonstrating a balanced approach that respects all individuals while maintaining necessary protections. Recent events across the country have shown us what happens when we remove these vital protections. We've seen incidents in schools, prisons, and public facilities where women's safety and privacy have been compromised. Women who speak up about these concerns are often dismissed or labeled negatively simply for advocating for their basic rights. I think about my daughter's future and the future of all Wyoming girls. They deserve the same rights and protections that their grandmothers and great-grandmothers like mine fought so hard to secure. This isn't about exclusion. It's about maintaining necessary, healthy boundaries that protect privacy, dignity, and safety. Wyoming has the opportunity to stand firm in protecting women's rights, just as we did over a century ago when we led the nation in women's suffrage. Our position as the equality state demands that we continue to lead on women's rights. I urge you to support House Bill 72.
Any questions for Ms. McCoy? All right, thank you.
Thank you.
Next.
Mr. Chairman, excuse me, I'm Bob McLaurin with WHAM. We're neutral on this bill. We had worked with the with the sponsors, but we could work within the bounds of the legislation. But I haven't seen the amendment that takes municipalities out, but we would support that. Our people want to do the right thing, and we don't think we need a law to do that. So we support the amendment and are neutral on the bill.
Any questions for Wham?
Thank you.
All right, thank you. Next. Come on up.
Good afternoon, Mr. Chair, members of the committee. My name is Matt Sharp. I'm Senior Counsel with Alliance Defending Freedom, and we support ensuring that women and girls have their privacy, safety, and dignity respected. In fact, just to your neighbors to the south, we're representing a family there whose middle school girl on a field trip to our nation's capital and to Philadelphia was assigned to share a room with a male in these hotel rooms on these overnight trips. The parents had no idea about it. The young girl was shocked when she gets into her room and finds out. And so legislation like this ensures that women and girls on trips, on school overnight activities, in women's prisons never are forced to share these intimate spaces with a male. 3 things about this bill we think are really important. Number 1, that it does set a clear standard. These definitions are scientifically sound, they're clear and easy to understand, and they set that standard so that policymakers know exactly what to do. Number 2, this empowers women to speak out. As we've heard so many times, women, when they feel uncomfortable when a man walks into their facility, may feel like they can't speak up. So setting a strong law that says you have a right to privacy in these spaces lets women know that if they feel uncomfortable, that if they believe a male has walked into their facility, that they can speak up to those facility owners and make sure that that individual is not allowed in. And the final thing is the legal remedy. This bill empowers women by ensuring that courthouse doors are always open to them when a government policy violates their right to privacy. Women deserve justice when men invade their private spaces, and without a remedy, that young girl on a school field trip who's forced to share a bed with a male, or that woman in a women's prison assigned to a male cellmate would have no recourse available to them. We thank you very much and happy to answer any questions.
Mr. Sharp, on the civil action portion of the bill, I want to get back to kind of Senator Hicks's question, and I'm trying to find it. Okay, yeah. So Senator Hicks brought up an interesting question. The way this is worded is it says that a person shall have a cause of action against the public facility that, and then there are various options. I'm just curious if if this cause of action against the public facility is accurate or more limiting, because you're not, you're suing the Department of Corrections, for example. You're not suing the medium correctional facility, which is the facility where it occurred. So speak to me about that language. Why is that language important? Go ahead.
Thank you, Mr. Chair. I think with both the definition of public facility and the definition of educational facility, they ultimately refer back to who is the entity that owns that building. So in the educational context, it's the school district or the University of Wyoming or other entity that owns it. With the definition of public facility, it's the building owned or leased by with the amendment state or state government entity. So that would ultimately be the party. As we know from court cases, you sue the final policymaker. This is the Supreme Court's decision in the Monell case. So in all of those, by referencing the public facility, you're ultimately talking about who owns that facility, who's the final policy and decision maker that controls whether someone is allowed to enter into opposite sex facilities or not.
Senator Crago.
Thank you, Mr. Chairman. So just a little bit of follow up on that. So if you turn to, I don't know if you have a copy of the bill in front of you, and I think this is important because if you turn to the next page, top of page 9, we talk about recovery of attorney's fees and costs from the governmental entity operating the public facility versus suing the public facility. And those are two, as the chairman pointed out, those are two very different things. And I just want to make sure we get it right. And so just help us understand why the two different scenarios there, because in the end, it's going to be one lawsuit. We're not going to be suing two different places. It'll be the entity. So help us with that if you could, please.
Mr. Sharp.
Thank you, Mr. Chairman. Again, I would go back to, in both of those definitions, these are all defined by who owns the building, who is the owner of it. And so with public facility, it is the government entity that owns or leases. I believe with the amendment, it would be the state or the state government entity that owns it. So with all of those, I think with the cause of action, when it says has a cause of action against the public facility, it's ultimately saying who owns that facility. It would be no different than, if someone slipped and fell at an ice patch on my house, ultimately they're going to be, the lawsuit would be against me, the homeowner, responsible for that. So the same thing here, by referencing those facilities and their duties, it ultimately, the responsibility goes back to who is that final decision maker and owner of the facility.
Okay, Senator Craigo?
Follow up, Mr.
Yes,
Chairman?
please.
Yeah, so on that, so should on page 8, should we be saying that shall have a cause of action against the governmental entity operating the public facility rather than against the public facility?
I was gonna ask that exact question. Because I think at least it would be consistent, you would have consistency in the bill at the very least. Mr. Sharp?
Yeah, Mr. Chairman, I think we'd be fully supportive of that to provide that clarity. That, I think, was the intent behind it. And so a simple addition to something like that, I think would be perfectly appropriate.
Perfect. Other questions from Mr. Sharp? All right, thank you.
Thank you.
Next.
Thank you, gentlemen. Sherry Davis from Cook County. I appreciate you men sitting there who probably all have sisters or wives or girls or grandchildren, and recognize the value of this bill in protecting them in intimate places, that there's no place for intrusion of the opposite sex. I think this whole policy thing is important for the institution because we see institutions creating policies that are allowing it. And so what we're saying is it's not okay if you have a policy. We've seen that in Gillette Rec Center, where they made their policy that you could go with the bathroom of your choice or the changing room of your choice. And my daughter was in there with my grandchildren, and there was a male in that women's facility. And so it was their policy that compromised my daughter-in-law and the grandchildren. So, maybe if you said if they don't have an enforceable policy to protect the rights, then that facility could be sued. Because I do believe the accountability is on the individual that's breaking the policy. We put laws in place to keep honest people on track and those that choose not to be accountable. And we do need accountability. We've seen in New Jersey that women in jail got pregnant and assaulted when men was allowed in their facility. We've seen in schools in Virginia where girls got assaulted because boys were allowed in their bathroom. We hear our superintendent here, we have a rec center here, there are real problems. And without a policy or law in place, we're very vulnerable. So I appreciate your consideration of this, and I trust that you'll handle it well. Thank you. I stand for questions.
Any questions for Ms. Davis? All right, thank you. Next. Anyone else in the room testifying? No? All right, go ahead.
Hi, my name is Ellis Roberts. I come to you as a citizen of Wyoming and a trans state employee. I felt the need.
I'm sorry, what was your name?
Ellis.
Ellis?
Yes. I felt the need to come and speak with you specifically regarding the statement by the representative that the solution in this policy to enforcing it as a citizen is to stop and ask questions if you don't know the person and they don't look woman enough. I'm not so much of a fool that I don't understand the momentum of this state and this country, but I beg you, when drafting, reviewing, amending policy, I'm begging you for grace and compassion for your neighbors. I moved here because I was not safe in my home. And I thought that I could be safe here because I believe that Wyoming was a state of good neighbors. And so I ask, as we work through this policy, if I am bleeding through my pants, is it fair that I sacrifice my dignity and my privacy because someone stops me because I don't look woman enough now, or in 2 years, or in 3 years? Is it fair that because of what I am, what I ran away from for so long, that I am asked to put my dignity on that altar? I want us all to be comfortable. I do. I don't know that anyone enjoys the public restroom. I don't. I don't know anyone who does. And I do think everyone deserves to feel safe there. I would ask that we find ways to feel safe, though, through community, through conversation, through connecting with each other as people, versus heavy-handed policies that are going to turn neighbor against neighbor. Thank you.
Any questions, committee? All right, thank you. Ms. Burlingame.
Thank you, Mr. Chairman. Thank you, committee. I'm Sarah Burlingame. I'm the Executive Director of Wyoming Equality, and we are in opposition to this bill. Although I will say that this bill probably has the best language to try to remove intersex individuals that we've seen in any of this bill drafting. Ordinarily, that is one of our chief complaints, that intersex people exist, that they exist probably to about the same rate that people who work in agriculture in the state of Wyoming exist, somewhere between 0.8 and 1.8% of our population makes their living from agriculture. Somewhere between 0.8 and 1.8 of our population is some kind of intersex. So if you know someone who ranches or farms, you probably know someone who's intersex as well. We do think that intersex folks are still caught up in this, but I think that this does the best job of trying to remove them from it, and it focuses as much as it can solely on folks who have intentionally transitioned their gender. So that leaves us where we always are, and what I think the individual who spoke before me said. We have the opportunity to have conversations with each other as neighbors and say, I'm not comfortable when this person is in the bathroom, or how do we create a facility where everyone feels safe and comfortable? Or we can bring in the heavy hand of the government and we can say everyone will be scrutinized. What the bill does not say, what it leaves absent, is the shape of that scrutiny. And there's no way to really open the door to it without being pretty graphic and saying, how does one prove that? We know that we can have amended birth certificates. So if the acceptance of a birth certificate where someone has transitioned is good enough, then for people who have gone through that paperwork and bureaucracy, they should be fine. That doesn't mean that they weren't assigned a different gender at birth. It just means that they have a different piece of paperwork. So in the absence of that, we are left with physically checking. And I would say that nobody wants the state of government to get in the business of getting in our business. Thank you. I'd stand for any questions.
Any questions for Ms. Burlingame? All right, thank you.
Thank you.
We will move to online testimony. I'm going to go ahead and drop it down to 1 minute for everyone online. And I ask that you be concise. Please not repeat any testimony that we've already heard. We want to get through everyone, but we do have work ahead of us, so we do need to move forward. Perfect.
Thank you, Chairman. My name is Britt Borrell, and I am a cisgender woman calling in from Casper to voice my strong opposition to HB 72. I was born and raised in Wyoming and was always proud to have grown up in the equality state. However, watching the state attack equal freedoms these last several legislative sessions has left me with a great deal of shame. I'm ashamed of the hate spewing from the legislators presenting these bills, hate from people who profess to be Christians following a Christ who commands them to love their neighbor. The joking questions posed by this committee about sagebrush obfuscate the harm this bill will inflict upon people. HB 72 is an example of gross government overreach. Every human being has to pee. Parents often accompany their children of the opposite sex to public bathrooms. I have often used the men's bathroom on our public lands when the women's is in a disgusting state or if it is occupied. So how exactly will this bill be enforced? If someone does not present as female enough or male enough, could they be required to undergo a genital inspection just to use the bathroom or the gym locker room? Would they be required to submit some kind of medical proof of genitals to the government? Who will maintain these files and evidence of children's genitals? The bills introduced this session attacking transgender people and children are couched in insincere language about protecting women. Make no mistake. Yes?
That is time. Thank you.
Thank you. Please vote no.
Next. Mr. Curtis.
Thank you, Mr. Chairman, members of the committee. I'm Jay Curtis, Superintendent, Park County School District Number 1 in Powell. I come before you today on behalf of my administration and board to support this bill, specifically the K-12 portion of it. This past November, my school board did pass a resolution to support legislation this session to create clarity around this issue for Wyoming school districts. The barriers that we're presenting at that time were both Title IX and conflicting case law around the country. As you're all aware, Title IX has shifted dramatically and is no longer a barrier to this. However, there still does exist tremendous conflicting case law around the country. So I would urge that Wyoming join the growing list of states that passes legislation such as this to provide clarity for local school districts. And that will specifically help us in the 10th Circuit where there is no case law in order to do so. I have a lot more to say, but I'm trying to be as concise as possible, and I would stand for any questions.
Yeah, and under the proposed amendment, Mr. Curtis, you're actually stricken from the bill. So the school districts under the definition is just a definition that changes it? Because you're striking page 4, line 3.
2 to 10.
That, oh, okay. All right. Your amendment is terribly confusing. I will say that bringing an amendment like that, it's difficult for us to track in, and we're all still trying to track it in. All right, next. Yes. Welcome.
Mr. Chairman, thank you. My name is Antonio Serrano. I'm the Advocacy Director for the ACLU of Wyoming. We're here in opposition to Senate File 72. We see this bill as singling out trans people for discrimination and excluding them from restrooms and locker rooms that match gender identity. This bill is bad for Wyoming because it would expose school districts in the state to costly litigation and have potential funding for education. Gloucester County School Board in Virginia paid $1.3 million in attorney fees after spending years unsuccessfully defending its policy of banning transgender students from restrooms that align with their gender identity. Bills like this make it harder for trans people to simply exist in Wyoming, and when you ban people who are transgender from using the restroom in government buildings and in schools, it effectively pushes them out of public life. You can't keep a job, attend class, or even access government services if you have to worry that they won't allow you to use the restroom. So when this law singles out people based on the fact that they have a gender identity that does not match their sex assigned to them at birth, it's discrimination on the basis of sex and trans status, thus triggering heightened and equal protection scrutiny under the Constitution. It is impossible to discriminate against a person for being transgender without discriminating against them for being based on the sex. All of us, regardless of race and backgrounds, all genders deserve to be ourselves and the right to safely exist in our communities as ourselves. I'm a parent. I have kids in school, and I want them, just like anyone, to be safe. Please vote no. Thank you for your time.
That is time. Thank you. Sometimes I don't know if they can hear me. Next. Ms. Byrne. Go ahead, Ms. Byrne.
Thank you, Mr. Chair. My name is Sharon Byrne, and I'm with the Women's Liberation Front. We are a radical feminist organization dedicated to preserving and protecting the rights of women and girls. We appreciate the Wyoming legislature putting forth this bill. We support the legislation to protect women's sex-based rights in public restrooms, changing areas, locker rooms, sleeping quarters. We especially appreciate the inclusion of prisons. Women's Liberation Front has long supported safe spaces for women, such as bathrooms, changing rooms, locker rooms, and any other spaces. The practice of making these restrooms and spaces all gender, particularly in schools, has led to voyeurism, assaults, and rape. This violates women's human rights by capriciously placing them in dangerous situations, and it's to accommodate the feelings of men seeking to enter women's only spaces. We are suing the state of California for putting men into women's prisons and can share testimony with you from female inmates on how inhumane and cruel a punishment this is. Again, I just want to thank you very much for bringing forward this bill and express our support.
Any questions, committee? All right, thank you. Next. Welcome.
Hi, thank you so much for having me. My name is Amber Bland, and I'm speaking from Casper in opposition to this bill. I will not try to appeal to your humanity and compassion for the reasons why I am against this, but rather I would like to demonstrate that the bill is objectively and undeniably unconstitutional. Article 1, Declaration of Rights, Equality of All is Section 2, and their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal. I would like to point out the obvious but apparently overlooked fact that there are no exceptions listed here. Section 3 touches on equal political rights. Its citizens shall be without distinction of race, color, and sex. Section 4 is security against search and seizure, the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. How in the world are we going to do this? Like, there's no way that this bill can be enforced without subjecting people's persons to unreasonable searches. With substantiated proof that this bill is unconstitutional and unfairly targets less than 1% of the population of this state, the question is why? Cruelty is the answer. This law will not protect women and children, nor can it be legally enforced in any way that does not constitute a significant violation of both individual privacy and Wyoming's collective founding principles. As a mother of three, I can confidently say I would rather send any one of my 3 children into a room full of trans people than entertain the idea of sending my 4-year-old son into a men's restroom alone.
Ms. Bland, that is time. Thank you.
So much more to say.
We all do. Unfortunately, we only have so much time. Next. That was the last person. Okay. All right. I will go ahead and close public comment. Committee, what is your pleasure? It's been moved by Senator Crum.
Mr. Chairman?
Yes, Senator Crum.
In the testimony today, we heard a lot about how this is for everybody, men and women, boys and girls. So with that, I'd like to propose an amendment to the title and drop the word women's and just use protecting privacy in public spaces.
Okay, is there discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Those opposed?
No.
No. All right, Senator Hicks, where are you? All right,
Using
well,
the sagebrush.
unfortunately, that does fail, Senator Crum.
Okay. Thank you, Mr. Chairman.
But good try. Okay, other amendments. What about our massive amendment we have here? And, you know, Representative Lawley, just as a pointer that of advice that I would give you, when you bring a substantial amendment like this that very materially alters the bill, one of the things that you can do that I've seen other legislators do that's really helpful is track it in for us. Give us a copy that it's tracked in, and then we don't have to track, because we're wasting time trying to track it in. I don't know if you have that. Just, we want to, if we're going to move this amendment, I really want to make sure I understand the idea of what you're doing, taking local governments out, taking county jails out, but we also got to make sure that it actually does that. Okay. That's all right. Thank you. Committee, you have amendments, Senator Crago? What about your amendment to the civil cause of action?
Mr. Chairman, so I'm not going to bring that right now because actually I think there's some confusion within the amendment regarding the terminology governmental entity. So under the proposed amendment, we would be deleting governmental entity, which is, I understand, might be defined in other places. And I understand that we're trying to tie it back to public facility. So if we go all the way back and we start with public facility on page 4, the proposed amendment would say public facility means any building or facility owned, operated, or leased by the state or a state governmental entity.
Exactly. Yep.
Well, what is a state governmental entity? That's not defined. I mean, and so if we go anywhere else in statute, governmental entity, including the word state, is going to be all governmental entities. And I think if we're going to do that, then we need to create exclusionary language saying this does not include local, does not include city, counties, special districts, et cetera. The problem is when we start digging through all the different types of local governmental entities, they're numerous. And so I understand what we're trying to do here. We might just have to spend a little bit of time, and maybe this is one we bring back on the floor and say, we worked it through the committee, we all agree it's something that needs to be done, but this language, I don't think quite gets us where we want to go. I think there's still confusion left in the statute or the proposed statute even after the amendment. I'm not sure we actually exclude cities and counties.
Senator Kolb?
Yeah, just on the amendment, Mr. Chairman. I like the bill the way it is. I don't think this amendment is helping me like the bill more. I mean, I understand the reasons why the amendment was proposed, and, you know, there's reasons, but I just don't like cutting this down. I just don't like changing it in this manner. First off, it's a huge lift, this amendment, huge. And it, you know, the first time I go try to track this in, and we've got things coming out that, you know, was thought to be an issue with schools, and it's apparently taken care of in some other places. But I think, you know, it's one for all and all for one here. We're trying to do something for the state of Wyoming to protect people, and it's more than just women. It's anybody who goes into a space that expects privacy in that space. And I agree with Senator Crum on that issue. And but this amendment is too much for me. I'm not going to support this amendment, I guess is what I'm trying to say. And for those reasons I gave, I like the bill. I like the bill a lot. I like what the bill's trying to do. I think it's what we need. But I just don't want to support this amendment at this point in time. I think on the floor, someone could bring it up, but I'm not in favor of it. Thank you, Mr. Chairman.
Yeah, even Representative Lawley, even trying to look at this copy that you just gave me, it does not track in all the changes from the amendment. So I'm looking right now at a page that half of it should be deleted, and that is still in the tracked in version of this bill. So it's really hard for us to double check to make sure that the amendment's doing what it's supposed to be doing. What are your
Mr. Chairman,
thoughts?
I would suggest if there's discomfort with the amendment, don't pass it. We can try to adjust a few other points I can work with. I was going to see if either you or Senator Crago, who are co-sponsors, are going to carry it on the floor. We might need to work out a few small issues if we don't do it this way, and that's fine. I really, you know, it's fine, and I do understand.
And I don't fully understand from a policy standpoint why, if we believe that this should be the policy in Wyoming, why we would restrict it to the state of Wyoming. Our local governments, I understand the jail can create some complications. I totally understood that. But with local governments, municipalities and counties, I don't understand why. The reasoning I heard from WHAM was we're gonna do what we're supposed to do. We don't need a policy to tell us that. Well, then we don't need this bill, because everyone will do what they're supposed to do, and that's not the way it works in the real world. Representative Lawley.
Thank you, Mr. Chairman. Again, I will just repeat, if the committee's uncomfortable with the bill because of, you know, too much too soon and under these circumstances, I understand. I sit on your side of the dais myself. So my suggestion would be, let's not waste any more time talking about it. To be honest with you, I know I'm the next bill up also, but to just don't.
And you want us to hear that bill?
It would be very helpful if you would do that, actually.
All right. Okay.
Question?
Any other discussion, committee? All right, let's do a roll call vote on House Bill 72. Oh, there is a technical amendment that was swallowed by your big amendment, but without your big amendment, we do need the technical amendment. This was brought to us by Palesso. You'll move that amendment?
Yes, Mr. Chairman.
Okay, it's been moved by Senator Crum. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right. Let's do a roll call vote on House Bill 72.
Senator Crago?
Aye.
Senator Crum?
Aye.
Senator Hicks?
Excused.
Senator Cole?
No, I'm sorry. Did Senator Hicks not leave a sheet with you?
No, you did not.
Okay, then excused.
Senator Cole?
Aye.
Chairman Olson?
Aye.
4 ayes, 1 excuse.
All right. Let's look at our next bill. House Bill 43. Welcome back, Representative Lawley.
Thank you, Mr. Chairman. Sorry. Mr. Chairman, if you're ready.
Yes,
I
ma'am.
am. Thank you, Mr. Chairman. Members of the House Judiciary Committee, I present to you House Bill 43, age verification for websites with harmful material, and I ask for your favorable consideration. Mr. Chairman, I've long been concerned about the safety of children online. I have grandchildren, and the growth, explosion really, of devices that connect to the internet and then to a world unknown and unregulated. I want to make sure that Wyoming is doing all we can to protect children from online pornography. The pornography industry employs sophisticated tactics to target children, such as pop-up ads, misleading links, and enticing visuals. And these are all designed to lure them into viewing explicit material. Age verification requirements would prevent a child's exposure to pornography. HB 43 requires internet sites that publish pornographic material, to provide age verification for access to their site, and provides significant and effective civil remedies for violations of HB 43. And it also requires that internet sites, as well as any third-party age verification providers, provide strict rules for data privacy and provide significant civil remedies of any violations of data privacy. So here's what the research shows, Mr. Chairman. The average age of first exposure to pornography is between 7 and 13 years old. By the age of 17, about 75% of adolescents have been exposed to pornography. 58% of individuals exposed to pornography for the first time access the material unintentionally. 88.2% of pornographic videos depict sexual violence, while 48.7% of the same videos include some kind of verbal abuse. You are going to hear today that there is a strong correlation between pornography, human trafficking, and sexual abuse. Sex trafficking is the supply side of the pornographic industry, and you'll hear more about that later. Studies reveal that pornography has the same effect on the brain as drugs. Porn is as dangerous as hard drugs or opioids to a young child's brain. Now, this doesn't diminish the harm of drug use, and particularly opioids, which is another problem in our society. It simply elevates the importance of this issue and the damage to children that can be something we cannot always see. Age verification requirements would prevent this unintentional exposure and I need a glass of water. Age verification requirements would prevent this unintentional exposure and reduce overall underage exposure to pornography. Age verification is not new. It's been used in Europe for several years, and age verification is not expensive or overly burdensome. With that, I'll quickly walk through the bill, and then I want to talk a little bit about the development of the case law in this area, which I think is very relevant, and even to some things you might hear as suggestions for amendments that I would ask for you to resist. If you go to page 1, we, again, beginning with a new section of statute, and as always, we begin with definitions. And I will just point out to you some of the key definitions. This statute is constructed in a special way, a unique way, that really, in many ways, takes in what's been learned by other states that have passed age verification, what some of the litigation showed. In particular, this was written after the Fifth Circuit decision upholding the Texas verification law and following that pattern. So something unique a little bit about this law and this bill is that we start with a definition of covered provider platforms, and that's on page 3. And that's a key definition in this bill, because this is what's going to determine if someone is covered by this bill. So covered platform means an entity that operates a website that in the regular course of business creates, hosts, or makes available content that is material harmful to minors and is provided by the entity a user, or other information content provider for purposes of making profit. Covered platform includes an entity described in this paragraph regardless of, and then there's some, whether they earn profits and some, if they create, host, or make available content to minors as the sole source. They don't have to, it doesn't have to be their sole source, but there's a key phrase in here that may become relevant later as others might suggest a different approach to how we do this. And that key phrase is in the regular course of business. Some states have done things where they will say if it's a percentage of your business, and that, which presents a lot of practical problems for plaintiffs who are injured because of the age verification not being properly used to prove what is a 1/3 of a digital business. But also in the recent Supreme Court case that was an appeal of the Texas Fifth Circuit opinion, the Supreme Court really zeroed in on this because the petitioner, who was the porn industry representative, basically used this 1/3 rule in the Texas law. They used it in that law as a reason that they might not meet strict scrutiny standard. So it can be used against us. It's a trap. It's a trap. So you may hear folks that ask to amend out this section and rather say in the regular course of business to do some kind of percentage. Some states did 10, some have done 30, 33.5%. But I would urge you to resist that. This is written in a way to make it very clear who's covered and who's not. There are many that have approached me in gaming, et cetera, and I always send them back to this definition for them to determine for themselves that they're not covered by the statute. And so, but it's clear who is covered. And then the next definition I would direct you to is on page 3 at the bottom, because basically simply because this definition from line 16 to 22 is taken from federal statute. Chose not to actually cite the statute. I'll cite it to you, but I didn't want to cite it here because it could change. And this language, though, is what fits this bill. So this and the next definition we're going to look at is from Federal Statute 47 USC 230F. And again, with the next definition, information content provider, it's if part of a federal statute, and that's how it's defined. We have definitions of what's materials that are harmful to minors. What is a minor? These are significant definitions as the court analyzes this idea of what's harmful to minors. The courts have long held that there's the compelling state interest to protect minors from obscene material. And so these definitions are important in that way. I would also tell you on page 4, point out that the definition of obscene comes from our statutes, and I do have it here, but I'm trying to stick as closely as I can to what we already have in Wyoming is what's obscene. And then the same concerning, there's another definition, excuse me, where we do the same thing, but we'll get to it in a minute. But basically then you see some of the things that are reasonable verification measures. You're going to hear in a little moment, I hope, from an expert online that in this technology and will answer a lot of questions about how it works, how it does protect privacy, what's the difference between identity verification and age verification, which becomes very important on the data side, but we still have strong protections on the data side. But these tell you, the next page, all the different ways, things you could use to verify your age. Then we have, on page 6, we have the things that these covered platforms cannot do. And they shall, and what they shall do and what they shall not do. They shall perform age verification. So what we've done here is we've placed the remedy and the solution the closest to the harm. Identify who the covered platforms are. They just have this obligation to provide age verification on their sites. And they also have an obligation to not retain any identifying information. And you're going to see there's private causes of action to deal with that because it's a very serious concern, the abuse of that. Then we see on page 7, a cause of action for knowingly retaining the identifying information. covered platforms are liable for those damages and attorney's fees for that violation, just as they are for the actual harm to a minor because they did not provide the age verification. So they're also, the covered platform is liable if they hire a third-party age verifying company, which is likely what they would do. And that company does not properly handle any data that they might have. So again, privacy protections and the requirements basically going straight to those covered platforms and those who act on their behalf. So there's some language in here that basically tries to prevent the foreign industry from using determinations in other states and other cases where the plaintiff wasn't a party, kind of a common law collateral estoppel is what we would probably call it as lawyers, but there's some provisions in there and that things that help protect the types of things that happen in this unequal balance sometimes in these situations. So to make it a clear and possible way for the civil remedies. One of the things I want to point out on page 9, and this is a policy decision, that kind of, again, goes around where we are in the development of the law here in this area. And that is that this bill only uses civil remedies, specific, targeted, effective civil remedies for the harm of the not having the age verification and the exposure of pornography to children, minors, and their parents have the right to sue and get damages. And then secondly, for the privacy violation. So why wouldn't we just throw in the Attorney General's already existing consumer protections? Well, maybe one day we will. But quite frankly, we do that and anything taken under that action could cause basically a suit to be filed for a preliminary injunction to just basically join the law. And there's no need to do that. These causes of action at this point protect us enough. And we don't have the state being involved in this area, which really gets delicate as we work through the law and where it is right now. So I think that's, that we have some exceptions that doesn't apply to on page 10. And the first one has to do with really actually the minor, him or herself, in terms of they have to be a permanent resident in Wyoming or have resided in Wyoming for more than 1 year, or they have been sojourning, one of my favorite words, sojourning for or present in Wyoming for not less than 31 consecutive days, because this is targeted geographically to Wyoming and residents of Wyoming. And then this doesn't apply to internet service providers, any affiliate or subsidiary of an internet service provider, and any general purpose search engine or cloud service provider. I've pointed out that part of the statute to a number of people that have come to me representing those. They're specifically and intentionally excluded. There's a provision on page 11 about contracts entered into in violation of this article shall be void. So not if they've already in place, but sometimes as a condition of using a site, there might be some little thing stuck in there that somewhat makes the enforcement of these provisions void. And we're basically, again, protecting these children, saying, no, it does not. And so, and then here we have basically, again, not altering contracts that already exist clause, and page 12, and then effective date of the act. And if you don't mind, Mr. Chairman, I'll just go back really quickly to the state of where we are in the law. So again, you can evaluate some as people come to you. So the Texas law, the Fifth Circuit vacated the district court injunction, and that case is currently under appeal to the Supreme Court, and the oral argument was January 15th. I listened to that argument this weekend. It was very instructive of the direction that we're taking in this bill and the support of the court for these things. In fact, the things that we're not doing in this bill were the things that even the petitioners, the porn industry, admitted if Texas had done them better and more targeted, they probably could have met the strict scrutiny tests. We also have Louisiana and Utah. They were both sued and their cases were dismissed in the district court level. even an appeal to the circuit court, federal circuit court upheld the ruling of the court, in part in the Utah case, because they had only civil causes of action. So that helps kind of explain the way the law is constructed. So again, you may hear how other states used percentages of varying degrees, and that's really the thing to do, but I ask you to resist that. I ask you to, again, remember that this law has been carefully tailored after the Fifth Circuit opinion in the Texas case. Let's see, the 1/3, any type of percentage puts an unnecessary burden on plaintiffs to basically try to establish that. You may hear that, well, this bill won't solve all the problems. It's not purporting to solve all the problems. It's taking an important step, and you'll hear from an expert, which I would like, just request, Mr. Chairman, we might let him he's online from England and got off, I think it's awfully early in England, but to testify on the age verification technology that might help answer some of the questions and the naysayers concerning the effectiveness of this technology. And so with that, again, I would just stand for any questions.
What's the name of your expert online?
Ian.
Okay, yep, I've got it.
Cool.
Senator Craigo?
Thank you, Mr. Chairman. So Representative Lawley, thank you for bringing the bill. Page 7, paragraphs, subsections B and D, are those covering the same thing and or not? And could you tell us how those work together? They seem to be covering the same thing, but I might just be reading them wrong.
Representative Lawley?
Thank you, Mr. Chairman. Representative Craigo, did you say C and D? I'm sorry, I didn't.
Mr. Chairman?
Yes.
B and D, Representative Lawley.
D and E over the next page.
B and D.
B is in boy,
Oh,
D is
there you
in
go.
dog.
Thank you. Thank you. Sorry. Well, Mr. Chairman,
Yes.
this is for B, page 7, line 4 is the cause of action for knowingly retaining identifying information. D is a provision that is for the same thing, but it's providing for including court costs and reasonable attorney's fees. So the one has to do with they may bring an action, and the other one is that what they can recover in that action.
Other questions for Representative Lawley? All right.
Thank you.
Thank you.
Mr. Chairman, I'm sorry.
Okay, Senator Crum.
I just have they're just two very quick questions.
Okay.
On page 6, just for my clarification, between lines 8 and line 17, it talks about getting the verification thing, and then it says starting on line 14 that they'll delete, get rid of the verification. So how is that regulated if they got to get it to verify age, but then they turn around and delete it? Who can regulate it or verify that they're actually doing this process? Would be my question, Mr. Chairman.
Representative Lawley?
Thank you, Mr. Chairman. I'm going to defer, if you don't mind, that question to our expert that is online and the way the technology works, how you could find out that they did save information. And again, talk a little bit about the difference between identity verification and age verification. I think that will clear that up.
Thank you, Mr. Chairman. And then my last question's on page 10, line, it's really 16 and 17, but on 17 it says, It's talking about who's it applied to, and that you use your great word again, sojourning, or present in Wyoming for not less than 31 days. My question would be, Mr. Chairman, what about a person that just went on vacation? They've been gone 14 days, they come back, they've been here 2 or 3 days. They haven't been here 31 consecutive days in the state of Wyoming. Now, they're a resident of Wyoming, but they haven't been here 31 consecutive days in the state. How does this work?
It's a list of,
Mr. Chair.
Senator Crum, it's a list of options. So if they're a resident of Wyoming, that's enough. There's an or on line 14, so it's just one of those have to apply.
Thank you, Mr. Chairman.
Yep.
Thank you.
All right, thank you, Representative Lawley. Public comment? Do we have any state agencies wishing to comment on this bill? No, I don't see any. Do we have public comment? You're all just here for the entertainment. Okay, let's go online and let's let Mr. Corby in. Welcome, Mr. Corby.
Thank you very much, Mr. Chairman.
And Mr., just so you know, we only have about 14 minutes to get through the remainder of testimony, work the bill, and then we have to leave. So understand that you might have a lot to say, but please only tell us what you think is absolutely important and be as brief as possible.
I made my plan for 1 minute, so I may take 2, but thank you for your time, sir. So my name's Ian Corby. I'm the Executive Director of the Age Verification Providers Association. We represent 30 companies from around the world, at least a third of which are based in the US, who do age verification and age estimation. And let me say at the outset that the essence of age verification is proving your age without disclosing your identity. So it's not identity verification. It's also cheap, it's quick, it's accurate, and above all, it's private. And we did, just to give you a quantity, about 1 billion age checks globally last year. So the bill before you sets out a number of ways you can do age verification, but essentially we do it with a third party. So you should never be handing your passport to Pornhub. You go through a trusted third party who does your age check. So we can do that with a driver's license or a passport. You might simply take a photo of your ID, a photo of yourself, and we check that the image on the ID matches the photo of yourself. That technology is clever enough now, it can all be done on your cell phone. So you never actually have to share that personal data beyond the palm of your hand. Obviously, if you've got a credit card, you're an adult, so we can check you've got access to that credit card and you can authenticate that. And then there's an option for other means that reliably and accurately prove your age. And this is where it gets interesting, because we can use facial age estimation, which is accurate plus or minus a year. Typically, we won't use that for somebody who's only just had their 18th birthday, but for somebody who sadly is as old as me, if I am estimated to look, say, over 25, there's statistically no chance that I'm in fact under 18. So we have a sort of a buffer age. Another method like that is based on moving your fingers. It turns out this tendon here between your thumb and your finger adjusts with age. And we've tested that solution and it's 99% accurate in discerning whether you're an adult or a child. And we can also do this with your email address or your mobile phone. So you may have used your cell phone when signing up to a utility, or you might have used your email address when you're doing a comparison for mortgage interest rates. These are things that only adults do. And if you've done enough of those things using your cell phone or your email address, then we can draw a very strong conclusion that you're an adult. There was a question just earlier about, well, if we have to throw away all that personal data and we don't retain the database, and please never retain that personal data. It's very dangerous to do so. It becomes a target for hackers. What we say is that the platforms would need to demonstrate to the court that they've used a reputable, ideally an independently audited and certified solution. We have 3 international standards against which you can be certified: an international standard, an IEEE standard, a British standard. And you would go to the court and say to them, yes, we're being accused of letting this child onto our platform, but I can reassure you, we use this particular provider. Here's all their certification. And this demonstrates that we will have been stopping the vast majority of children getting onto our websites. So that's how the system works. We also have clever ways of using one age check on one site and then reusing that across multiple other sites without having to redo that, albeit only maybe 10-second process. And I agree with what the Representative Lawley was saying about placing the control as close as possible to the harm. People access the internet in all kinds of different ways. You'll soon be able to look at the internet on your fridge. So it's important that we go as close to the harm as possible. And that's why we place the responsibility on the platforms themselves to prevent people accessing harmful content if they're underage. I'm more than happy to take any questions you may have.
All right, Senator Crum, sounds like you got your one question answered.
Thank you, Mr. Chairman. Yes.
Okay. Senator Kolb.
Yeah, thank you, Mr. Chairman. Good day, Mr. Corby. Hope it's not too late at night over there. The question I have is liability. Your consortium of folks that do this age verification or age verification, use the right set of words here. Why wouldn't you be responsible if somebody got through the system and accessed a site after they went through your verification process and it didn't work right, whatever reason it didn't work right? I'm trying to understand just how this it hasn't really been laid out in a logical step-by-step manner here on I know what we're trying to do, but on how we're going to do it. Basically, I wonder if you're I assume you're representing people that do age verification, in some methodology like you laid out. Don't you have some liability for, I guess, not getting that right? Would be the first thing I'd ask. Thank you, Mr. Chairman.
Mr. Corby.
Thank you, Senator Cole. Mr. Chairman, the primary responsibility for compliance will always rest with the adult platform, with the porn site. So they're the ones that are going to be subject to the private right of action and taken to the court if somebody discovers their child is accessing their site. So they could choose to try and obviously manage the age verification in-house. If they outsource it, they will do so through a contract. They will exercise due diligence in who they appoint to deliver that contract. And they will obviously have an agreement in contract as to what happens when it goes wrong. Those are obviously individually negotiated commercial arrangements between the porn site and their age verification supplier. But there will be an arrangement, obviously, but you have to leave the responsibility with the owner of the porn site rather than allowing them to simply you shift that entirely onto somebody else.
Any other questions from Mr. Corby? No. All right, thank you. Appreciate it.
Thank you.
Representative Lawley, do we have like a one-page handout that summarizes the technology, or did you use something like that? You do? Okay.
There was a question I had. Sorry.
You have another question for him?
I do, if it's possible.
Okay.
If not, we can just ask. Up to you,
He's
Mr.
back.
Chairman.
Go ahead,
he's
Senator
back.
Cole.
Oh. Let me turn the mic on. Sorry. Probably can't hear me from over here. The question I had was, it keeps on eluding me.
I'd be surprised if you don't ask about virtual private networks.
Yeah, I know you knew the question I was going to ask, but yeah, I don't want to give a sense of security to people. I realize I think we're doing a good thing here. Age verification is necessary. It's a good thing. But how do you get around? I mean, is there technology out there that gets around VPNs when you're going all over the world on a hop and they don't know where you came from? I guess I'm just looking for an answer for that. I think we capture a lot of people by doing this, but I don't know if we capture all the people. I don't want to give people a false sense if it sounds like maybe that would be a workaround. So that's the question. What the VPNs, are they a workaround? Thank you, Mr. Chairman.
Mr. Corby.
Thank you, Senator Kolb. Mr. Chairman, I always describe this as the VPN fallacy. So Pornhub have made a great noise about the fact that they are blocking access to states, some of the 20 other states that have this law. They're not blocking access. They're blocking access to people who are using IP, Internet Protocol addresses registered in that state. And so people can very easily, as you point out, use a virtual private network to pretend they're in a different state or even a different country altogether. But none of those laws in any of those 20 states has an exception that says we want to prevent children in our state seeing porn unless they're smart and rich and have access to a VPN, in which case we don't mind if they see porn. The liability still remains with the adult site if they are found to allow children on. So those sites need to be sure that the people accessing them are not in a state which requires age verification. And bear in mind, we are now at 20, and I'm talking to another 10 in this season of legislation. So we could be at 30 by the end of the year. And they need to do that in the same way as the online betting companies do when they have to check that you are in Nevada if you're going to make a bet. And they don't just use IP addresses, they use GPS, they use which Wi-Fi you're on. And bear in mind also, sports TV channels, Netflix, the BBC, they can all use systems to identify when you're calling through a VPN, and they often block those anyway. So the alternative would be for the adult sites to just block their VPN traffic if they prefer to do that.
Anything else for Mr. Corby? All right, thank you.
Thank you.
We have other public testimony online? Okay. Mr. Combe, welcome.
Hello, Mr. Chair, can you hear me?
We can hear you.
Okay, great. Thank you for your time. I will be really quick. My name is Joseph Combe. I'm the policy director at Family Policy Alliance, and I'm an attorney. I'm here to encourage you to vote yes on this bill as a matter of restoring parental rights. As you've heard and as you've seen from some of the research, studies show that by the age of 17, almost all children have been exposed to pornography. And this is made possible by the fact that these pornographic websites are accessible without parental permission through age verification. But we all believe parents have the right to and the ultimate responsibility of directing the upbringing of their children. So therefore, these age verification requirements for adult websites are absolutely necessary to restore that right to parents and put them back in the driver's seat of the rightful place of controlling whether and how their children engage with this kind of material and ultimately how they learn about sex. So the debate over whether pornography harms children is over. The research shows us that most pornographic videos depict either some kind of sexual violence that's either physical or verbal. Studies also show that most people who see these videos actually believe the lie that pornography is an accurate portrayal of sex. And what this means is that adolescents who see pornography are learning about sexuality from a perspective which portrays sex as physical abuse instead of receiving age-appropriate sex education from a parent or guardian. And because they are believing that lie, they are acting out that violence amongst themselves. Pediatric sexual assault, where pornography exposure is the only risk factor among the underage offenders, is on the rise. Research also reveals that of those children who have been exposed to pornography, most of them access the material unintentionally. So this means that adolescents are becoming exposed and addicted to pornography accidentally through interactions with certain websites that age verification requirements and parental involvement could have prevented. They weren't looking for the porn found them. That is how the internet works now. And finally, right now, the average age of first exposure to pornography is between the age of 7 and 13 years old. There could be no clearer mandate for this essential legislation to restore parental rights to protect children from pornography. And the last thing I'll say is that these bills are entirely constitutional, and the Supreme Court is very likely to rule in favor of that by the end of this term. So with that, I'm happy to take any questions from the committee.
Any questions, committee? All right, thank you.
Thank you.
Next. Ms. Rangel, you're up next.
Hello, can you hear me?
We sure can.
All right, I will be quick. I am the Director of Public Policy for Exodus Cry. We're an anti-trafficking organization. I want to testify today in support of the bill. I will start with saying that pornography is not for children. I have worked for decades in the fight to protect children against the harms of the sex industry. At no other time in human history has mainstream pornography been, one, so accessible to children and youth, and two, so graphic, hardcore, and violent. It is impossible for me to testify on the accessibility of pornography for children without talking about what modern online pornography is. A recent study showed that 45% of videos from Pornhub and 35% of sex video scenes included at least one act of physical aggression. Men inflicted the violence 75% of the time, while women were the victims of this violence 97% of the time. The most commonly used forms of aggression were gagging, slapping, and choking. Violent pornography promotes the belief that the acts of physical violence, sometimes criminal acts of violence, should be enjoyed during sex acts. These violent pornographic videos promoting criminal activity are not the anomalies, they are the norm. Current mainstream pornography is not the sex education we want for our children to have, regardless of what community they are a part of. With a simple Google search of abuse porn, one website alone has 61,459 videos under the title 18 and abused. Another popular website, rapelust.com, self-advertises on the Google search page as, quote, watch sexual abuse rape porn now in HD. See the best sexual abuse sex videos for free, end quote. A recent study showed that over 50% of the content on Pornhub's homepage was incest themed. One of the most popular channels on Pornhub that boasts over 691.4 million views and consists of over 500 videos is called My Perv Family. Children are recklessly accessing incest-themed intra-family sexual abuse that erroneously demonstrates that being sexually abused by a step-sibling or step-parent should not only be tolerated, but welcomed. Pornography is the root of sex trafficking and has exponentially increased the amount of child-on-child sexual violence. In 2020, Ruben Andre Garcia was sentenced to 20 years in prison for conspiring with the owners of Girls Do Porn to use force, fraud, and coercion to recruit young women to appear in sex videos on adult websites. Garcia and his co-conspirators threatened to sue victims, cancel flights home, and post videos online if they did not finish the videos once they started. The other owner, Michael James Pratt, who was previously a fugitive and on the FBI's top 10 most wanted list, was arrested in Madrid, Spain in 2022 and was extradited to the United States to face justice for the videos he recorded and uploaded to Pornhub. He faces 19 felony accounts stemming from operations of Girls Do Porn on Pornhub, and these charges include 15 counts of sex trafficking. There are other current ongoing lawsuits for this same thing. Jane Doe number 1 from a lawsuit was drug raped and filmed with videos posted by her sex trafficker onto Pornhub when she was 16 years old. Jane Doe number 2 of the same lawsuit was allegedly...
Hey, Ms. Rinkle, we're
Yes.
running really short on time. We're supposed to be back in our chamber 2 minutes ago.
Okay,
I have to
let
cut
me
you.
just wrap it up. What
Wrap.
may be mainstream for adults is clearly obscene for children, and it must be treated as such. It is paramount that age verification laws be allowed to do their purpose and keep our children protected from online pornographic content. Thank you.
Am I okay to talk?
Oh, sorry, my microphone wasn't on. I kept saying, go ahead. Go ahead.
Thank you very much. Sharon Byrne with the Women's Liberation Front. And obviously, as feminists, we're going to have a very strong stand against porn. One thing I would invite all of you to do is a quick search on your phones for choking girl anal. And you will see the violent plethora of films that are available on Pornhub and other sites. There are girls showing up in emergency rooms across the country with anal tearing and choke marks on their neck and wondering why it is that they don't like sex. I appreciate that you've asked a lot of good questions about age verification. You already have it in practice in your bricks and mortar stores. It's long been established that you can't just go in and buy a dirty magazine or go into a strip club without flashing ID. The internet's no different. Our organization has supported this law being passed in 19 states in the United States. We also helped defend Texas's law before the Supreme Court in January. And a couple of things I want to point out to you from that hearing, because we listened to the Supreme Court. Gorsuch in particular asked some questions about age verification, and is it too onerous? And basically the answer was, well, you already have to provide a lot of ID to do things with your credit card, to get a gun permit, et cetera. And so The Supremes didn't seem that concerned about age verification as an impediment to the porn industry. They also were very clear that most 15-year-olds can easily out-tech their parents, so kicking it to the tech companies wasn't the right answer. And they did seem inclined to support Texas's law, or at least parts of it in place. So I wanted to reassure you of that's the latest development from the Supreme Court on the Texas case. I appreciate the thoroughness of this bill. This is the most thorough legislation I've seen on to do age verification to date. So congratulations to Wyoming and to Representative Lawley for bringing that forward. And we just want to express our support for this bill. Thank you very much.
Any questions, committee? All right, thank you. With that, I will close public comment. Committee, what is your pleasure?
Move the bill.
Bill's been moved by Senator Hicks. Are there any amendments to this bill?
I've got one.
Senator Kolb?
Yeah, page 1, line 14. The question, I guess, it would be changing obscene to pornographic material. I think obscene limits the scope of this bill. And obscene is defined by the Supreme Court for quite a while. It's a discussion item. It would seem that we want to broaden this up. If we're going to talk about pornography, we shouldn't use the word obscene.
Senator Crago's dying to weigh in here.
Yeah, Mr. Chairman, I don't think that's a good idea. If you go to page 4, obscene, it's already defined in statute, and I don't think we want to mess around with that.
Oh, it's in Wyoming
So
statute.
Yes.
keep it as.
Correct.
Well, I withdraw my thought. Thank you.
All right. That's good. Any other amendments or discussion on this bill? All right, Pierre, will you please do a roll call vote on House Bill 43?
Senator Crago?
Aye.
Senator Crum?
Aye.
Senator Hicks?
Aye.
Senator Kolb?
Aye.
Chairman Olson?
Aye.
5 ayes do pass.
All right, thank you, Representative Lawley. Here's your tracked in bill.